Hello everyone. This presentation attempts to introduce two important subjects of law which would be of immense use to law students in understanding and appreciating various concepts and principles in law and interpreting the provisions of any legislation. The first one is jurisprudence. What is jurisprudence? The word jurisprudence comes from Latin expression jurisprudentia, which means knowledge of law or skill in law. It is the study of law as a system of knowledge. Jurisprudence synthesizes all the essential principles of law in a scientific manner. The rules and principles laid down in tort law, law of contracts, criminal law, etc., are derived from authoritative sources and they are applied in fact situations to solve problems and resolve disputes. Jurisprudence does not consist of such rules and is not derived from authoritative sources and hence appears to be without any practical application. Only on analyzing the nature and scope of the subject will one be able to understand and appreciate the importance of jurisprudence. Jurisprudence deals with the nature of legal rules, meaning of legal concepts, and essential features of legal systems. In law, we look for rule relevant to a given situation. Jurisprudence looks for the reasons why a rule is a legal rule. The nature and working of law, like advantages and disadvantages of codification, the importance of the system of precedents, and the methods of legal reasoning, be it analytical, historical, or sociological, fall within the purview of jurisprudence. Analysis of legal concepts like rights, duties, intention, negligence, ownership, possession, person, property also fall within the ambit of jurisprudence. Legal theory is concerned with the analysis of law as it exists, the functions of law in a society, the way in which the law is created and enforced, the influence of social opinion on law, the effectiveness of law, and the part played by sanctions. Jurisprudence links law with other disciplines like sociology, history, and economics and helps to locate it within its wider social context. Legal concepts, when analyzed, are presented against a background of social developments and the changing economic and political attitudes of the society. Thus, the logical analysis of legal concepts sharpens the analytical and reasoning skills of lawyers. Unless we understand the circumstances under which various principles, concepts, and laws were created and evolved, we will not be able to appreciate their significance, and jurisprudence would help a law student in putting these principles, concepts, and laws in their proper context and using them as efficient tools in the administration of justice. Now, let us understand the significance of including interpretation of statutes as a subject of study in the law courses. Every nation generally has three organs of governance: the legislature, the executive, and the judiciary. The legislature, as a representative of the people of a nation or state, expresses its will, and such expression of the will in accordance with provisions of constitution is a statute. It is the responsibility of the legislature to determine what is best for public good and to provide for it by proper legislation. It is the province of judiciary, consisting of independent, impartial, and competent judges, to explain or interpret the law for resolving the disputes brought before it. In ordinary life, when someone writes to us and his meaning is not clear, we can write back to him and ask him what he meant or what he intended. But this cannot be done in the case of a statute if there is ambiguity in the meaning of a statute. If we leave it to the discretion of a judge to resolve the confusion without laying down any rules for doing so, there may be violent difference of opinion as to the meaning of a statute. Hence, certain acceptable rules of interpretation have been evolved, and every student of law must know these rules. This is necessary because almost all our rights and liabilities are the subject matter of the statutes, and the problems that now arise have their source in the meanings of words rather than in conflict of ideas. It is by giving the correct meaning to the words of a provision in a statute that a lawyer can say what the law is. The subject contains general rules of interpretation, presumptions, and internal and external aids to interpretation. The manner in which a provision has to be interpreted depends upon the nature and object of the enactment. Thus, rules used to interpret constitutional provisions would not be the same as those used in interpreting a penal or a taxing statute. What is the effect of a repeal clause, and when can retrospective operation be given to a provision of an enactment are also discussed here. Therefore, in order to properly understand and appreciate the provisions of any statute, a thorough knowledge of these rules of interpretation is necessary, and hence it becomes inevitable for every lawman to have a fair knowledge of these rules. Thank you.